Wayte v. United States Supreme Court, 1985. Justice Powell delivered the opinion of the court. David Wayte was a war protester. When he refused to register for the Selective Service System, he was warned that he could be prosecuted for violating the Military Selective Service Act. Nonetheless, Wayte continued to protest the war and refused to register. In a letter to the Selective Service System and President, Wayte stated, "I decided to obey my conscience rather than your law. I did not register for your draft. I will never register for your draft. Nor will I ever cooperate with yours or any military system, despite laws I might break or the consequences which may befall me." Ultimately, he was indicted. He then moved for dismissal, contending that he was selectively prosecuted for resisting the system. The district court granted the motion. The respondent government appealed, asserting that the petitioner did not prove a prima facie case of discrimination. The question presented is whether a passive enforcement policy under which the government prosecutes only those who report themselves as having violated the law or who are reported by others violates the First and Fifth Amendments. Petitioner moved to dismiss the indictment on the ground of selective prosecution. He contended that he and the other 13 indicted non-registrants were vocal opponents of the registration program who had been impermissibly targeted out of an estimated 674,000 non-registrants for prosecution on the basis of their exercise of First Amendment rights. In our criminal justice system, the government retains broad discretion as to whom to prosecute. So long as the prosecutor has probable cause to believe that the accused committed an offense defined by statute, the decision whether or not to prosecute and what charge to file or bring before a grand jury generally rests entirely in his discretion. This broad discretion rests largely on the recognition that the decision to prosecute is particularly ill-suited to judicial review. Such factors as the strength of the case, the prosecution's general deterrence value, the government's enforcement priorities, and the case's relationship to the government's overall enforcement plan are not readily susceptible to the kind of analysis the courts are competent to undertake. Judicial supervision in this area, moreover, entails systemic costs of particular concern. Examining the basis of a prosecution delays the criminal proceeding, threatens to chill law enforcement by subjecting the prosecutor's motives and decision-making to outside inquiry, and may undermine prosecutorial effectiveness by revealing the government's enforcement policy. All these are substantial concerns that make the courts properly hesitant to examine the decision whether to prosecute. As we have noted in a slightly different context, however, although prosecutorial discretion is broad, it is not unfettered. Selectivity in the enforcement of criminal law is subject to constitutional constraints. In particular, the decision to prosecute may not be deliberately based upon an unjustifiable standard such as race, religion, or other arbitrary classification, including the exercise of protected statutory and constitutional rights. It is appropriate to judge selective prosecution claims according to ordinary equal protection standards. Under our prior cases, these standards require petitioner to show both that the passive enforcement system had a discriminatory effect and that it was motivated by a discriminatory purpose. All petitioner has shown here is that those eventually prosecuted, along with many not prosecuted, reported themselves as having violated the law. He had not shown that the enforcement policy selected non-registrants for prosecution on the basis of their speech. Indeed, he could not have done so given the way the beg policy was carried out. The government did not prosecute those who reported themselves but later registered, nor did it prosecute those who protested registration but did not report themselves or were not reported by others. In fact, the government did not even investigate those who wrote letters to the Selective Service criticizing registration unless their letters stated affirmatively that they had refused to comply with the law. The government, on the other hand, did prosecute people who reported themselves or were reported by others, but who did not publicly protest. These facts demonstrate that the government treated all reported non-registrants similarly. It did not subject vocal non-registrants to any specific burden. Indeed, those prosecuted, in effect, selected themselves for prosecution by refusing to register after being reported and warned by the government. Even if the passive policy had a discriminatory effect, petitioner has not shown that the government intended such a result. The evidence he presented demonstrated only that the government was aware that the passive enforcement policy would result in prosecution of vocal objectors and that they would probably make selective prosecution claims. As we have noted, however, discriminatory purpose implies more than intent as awareness of consequences. It implies that the decision maker selected or reaffirmed a particular course of action, at least in part because of, not merely in spite of, its adverse effects upon an identifiable group. In the present case, petitioner has not shown that the government prosecuted him because of his protest activities. Absent such a showing, his claim of selective prosecution fails.